Well, let's look a little bit at next term, the fall term. One of the cases that the court is hearing is on affirmative action. And I'm a little confused by this because I feel like the court just heard a case about affirmative action with the Fisher case in 2016. Why is it hearing another case about affirmative action?
Well, it's not clear yet whether they will hear this case, but this is a case challenging Harvard's affirmative action program, and the contention is that by disproportionately favoring some applicants of color, they are discriminating against other applicants of color, essentially disadvantaging Asian Americans while disproportionately advantaging African American and Latino applicants. The district court in Boston ruled against the challengers, upheld the program. The First Circuit Court of Appeals upheld that decision, ruled for Harvard, but the challengers have asked the Supreme Court to review the case. And, if the court reviews the case, very unlikely, I think, that affirmative action survives, because there are, I think, I mean, we could be pleasantly surprised, but I think there are at least 5 and quite possibly 6 justices who believe that we should not be taking race into account in admissions to universities, period. And, end of story. And, about 20 years ago, the court said, in upholding an affirmative action program in Michigan, that this should be a temporary thing, and it shouldn't, it should be gone in 25 years. And so we're getting close to 25 years, and we have a much more conservative court. And there's among the conservatives, there's a very strong view, especially strongly held by Chief Justice Roberts, that, the way to end racial discrimination is to end discriminating on the basis of race. And that includes discriminating on the basis of race in ways that advantage people of color as well as ways that disadvantage people of color. They might duck it, but they have asked the United States for its views on whether they should take it up. And given how strongly, I think, particularly Chief Justice Roberts feels about this, I think there's a real risk that they take it up. And and so if they already have on their docket an abortion case and a guns case. So if they take that up, then they've got abortion, guns, and affirmative action all in the same term. That is going to be a blockbuster term.
Well, can you talk a little bit about the abortion case? It's the Dobbs v. Jackson Women's Health Organization, and people are characterizing this case as the first abortion ban case since Roe v. Wade. But there have been a number of other abortion cases, one as recently as last year. So how is this one different? Like, why could this one risk overturning Roe?
So the reason people say this is the first abortion ban case is that since Roe, it has been, the one thing that has been clear is that before the fetus attains viability, the pregnant woman has the right to decide whether to terminate the pregnancy or not. After viability, the state can prohibit abortion unless it's necessary for the health or life of the mother. But before viability, the rule has always been, it is the woman's choice. So the issue in all the abortion cases has been, has the state interfered with the woman's choice by imposing onerous requirements on her, or making it really hard to get to a facility, or making the person, go twice to the facility. It's those sorts of more subtle obstacles. But this is an absolute ban. After 15 weeks, if you don't have your abortion by 15 weeks, you cannot get an abortion in Mississippi. And so that's an absolute ban. And the question in the case is whether the court should essentially reconsider the core principle of Roe, which is that before viability, it is the woman's choice. The state can, express its views. It can provide for informed consent. It can urge her to bring the child to term, but it cannot forbid an abortion. And so that the Dobbs versus Mississippi is a huge case. It's also huge because, it'll be the first opportunity that we hear from Gorsuch, Barrett, and Kavanaugh on this question.
I'm curious, have anti-abortion activists sort of already won a major victory just by the fact that the court decided to take this case?
Absolutely. Absolutely. I mean, I think, they had denied cert in a number of similar cases over the years. So, I think the concern is that once Barrett came on the court, they may have enough votes to seriously undermine Roe versus Wade. Now, whether they will or not, I don't think we can say at this point.
Right.
I think, we need to do everything we can to make clear why they should not overturn or restrict Roe versus Wade. And there was one time about 20 years ago in a case called Casey versus Planned Parenthood of Pennsylvania, where again, similarly, the argument was made, Roe should be overturned. There were 5 justices who pretty clearly were critical of Roe, and people thought there was a real risk that it would be overturned. And at the end of the day, Justice O'Connor and Justice Kennedy said, no, we're going to stick with stare decisis. And, they modified Roe in Casey, but they, kept its core. So we'll see.
Let's end with gun rights. What is this case? And, also, do we take a stand on this one? I feel like the ACLU in general sort of steers clear of the Second Amendment and cases around it. But are there larger civil liberties concerns with this particular case?
So this is a case about whether the Second Amendment protects the right to carry a concealed weapon in public. The court has held that the Second Amendment protects the right to own a gun in your home, but they haven't yet extended that right to the right to carry a concealed weapon in public. And New York says, if you want to carry a concealed weapon in public, you have to show us that you have a real need to do so, and then you get a license. And they're arguing that that's a unconstitutional infringement on the right to bear arms. The ACLU, we are preparing an amicus brief in the case, and which we're essentially arguing that, even if there is a right to bear arms, it is subject to reasonable regulation. And one of those reasonable regulations could be to say that you have to have a reason, you have to show good reason to carry a weapon in public, because if everyone can carry a weapon in public, it will undermine public order, and in particular will undermine public debate. I mean, the notion of the free right to associate, to express your views, to demonstrate, would be seriously challenged if you had to fear that people who disagree with you are going to be armed and going to pull out a gun and shoot you, in the midst of a demonstration. So I think our argument is going to be that First Amendment concerns support the reasonableness of states putting fairly strict restrictions on this right, even if it is a right.
Just to wrap up, we talked about earlier how Chief Justice Roberts wants to appear nonpartisan. As mentioned earlier, he also believes in an incremental change and managed to keep the court away from sweeping decisions this term. Do you think the same will be true for next term, given the cases on the docket?
So I think the challenge is going to be much, much greater. The true test of whether they can sort of rise above partisan division will be presented in cases like the abortion case, the guns case, if they take the affirmative action case. Those are going to be real tests of whether the court can rise above partisan division and decide cases on the basis of law rather than politics. So TBD.
Thanks so much for joining us. If you enjoyed this episode, subscribe to the channel and click the notification bell. Or subscribe to At Liberty wherever you get your podcasts and rate and review the show. We so appreciate the feedback. Until next time, stay strong.